You've come to the end of your tenancy and your landlord's refusing to return your deposit. What can you do about it? This video explains. I'm Daniel Barnett, a barrister practicing in London and the presenter of the Legal Hour on LBC Radio. In this video, I'll explain when a landlord can keep your deposit, how to challenge deductions, and how to take your landlord to court. If you want to stay up to date with my other videos, do subscribe to my channel and click the notification bell. Thank you. Under the rules of contract law, your landlord is only entitled to withhold your deposit if you've caused them financial loss. The amount deducted has to be reasonable and the landlord should provide evidence of this loss. This means your landlord is entitled to deduct money from your deposit if you've fallen into arrears with your rent, if you've damaged the property in some way, for instance by staining a carpet or scratching the floor, if you've broken furniture or other items that were supplied with the property, if you've redecorated or made substantial alterations without the landlord's permission. Even if one of these categories applies, remember the deductions must be reasonable. It would be unreasonable for a landlord to deduct more than the amount of your arrears or more than the cost of remedying the specific damage that you've caused. If you've redecorated or altered the property without permission, they're only entitled to deduct the cost of putting things back to how they were, not the additional cost of making improvements. Although many landlords and lettings agents charge tenants for wear and tear, that isn't legally permissible. If reasonable wear and tear has been caused by ordinary use of the property over time, it can't be regarded as loss that you've caused the landlord. It's an ordinary expense for the landlord of letting their property. Another common deduction is for cleaning expenses. A landlord can use part of your deposit to pay for professional cleaning, but only if you've left the property less clean than it was when you moved in. A deduction can only be made for gardening expenses if you failed to leave the garden in roughly the same state as it was when you moved in. As with decoration, it's not legal for a landlord to use your deposit to effectively improve a garden. A landlord cannot lawfully penalise you for a breach of your tenancy agreement that's caused them no financial loss. So, for example, if you've secretly been keeping a pet, the landlord can only deduct money from your deposit if damage has been caused, not simply because you broke the agreement. If you haven't already left the property, take photos of any damaged or any worn items to use as evidence if a deposit dispute arises, as well as photos showing the general state of cleanliness when you left the property. It's really helpful to have evidence of the condition of the property when you first moved in as well, either by taking your own photos or keeping a copy of the letting agent's listing. A schedule of dilapidations, if you can get hold of one, is fantastic. If you accept you've caused damage but want to challenge the amount of the deduction, it's helpful to get your own repair estimates from local traders, which might show the amount you're being charged is unreasonable. Landlords are sometimes more willing to return an unlawfully retained deposit if you can show they've broken the rules in other ways. Sections 1 and 2 of the Tenant Fees Act 2019 makes it unlawful for a landlord or a letting agent to require a tenant to make a prohibited payment. Now, if a deposit exceeds 5 weeks' rent, and the amount of rent payable is less than $50,000 a year, the excess over the 5 weeks is a prohibited payment under Schedule 1, Paragraph 2. Section 8 allows a local authority to fine the landlord in those circumstances. And if your tenancy is an assured short-hold tenancy, Section 213 of the Housing Act 2004 requires your landlord to protect your deposit using a deposit protection scheme. If they don't, subsection 4 says a court must order the landlord to pay you a sum of money not less than the amount of the deposit and not more than 3 times the amount of the deposit. That's in addition to requiring the landlord to return your deposit or place it in a deposit protection scheme. You can apply for this compensation if you take court action, and there are many solicitors who do this on a no-win, no-fee basis. If some or all of your deposit is being withheld unlawfully, your first move should be to write to your landlord explaining why you're entitled to a refund. Organisations like Shelter provide template letters that you can adapt. I've included a link to show theirs in the show notes below. Allow at least 10 days for a response. Attach any photos or any estimates that support your argument to your email or letter. You're more likely to get what you want if there's convincing evidence showing the deposit shouldn't have been withheld. If your deposit isn't returned, your next step should be to raise a dispute with the deposit protection scheme used by your landlord, the Deposit Protection Service, the Tenancy Deposit Scheme, or My Deposit. This is a free, independent process. An adjudicator examines the evidence provided by you, examines the evidence provided by your landlord, and decides how much of the deposit should be returned. Unfortunately, this process is only available ridiculously where the landlord agrees to use it. It's also not available where your deposit doesn't need to be protected. For example, if you have a license rather than a tenancy. If neither of these approaches work, your only option is to take the landlord to the small claims court. Before you start a claim, be aware of potential pitfalls. You'll need to pay a court fee, and though you don't need to pay for legal representation, the process can be time-consuming. Depending on the terms of your lease, you may also need to pay the landlord's expenses if you lose. Before you start your claim, you need to send a document called a letter before action, or a letter of claim, to the person withholding your deposit. This should reiterate the reasons why the landlord is legally obliged to return your deposit. It should remind the landlord of the steps you've taken to resolve the dispute, and it should explain you'll be taking legal action if they don't resolve the dispute. The practice direction, Pre-Action Conduct and Protocols, says the landlord should respond within a reasonable time, 14 days, in a straightforward case. Your letter should remind them that they need to do so. You also need to disclose key documents relevant to the issues in dispute, so make sure to send any key evidence, including any photographs or quotations. To start your claim, you can either use the online portal Money Claims Online or Court Form N1. A link to the form and to the accompanying guidance on completing it are below this video. Make sure you attach all relevant evidence. If the landlord doesn't reply within 14 days of being served with your claim, Rule 12.4 of the Civil Procedure Rules allows you to apply for default judgment against them, meaning you'll avoid a full hearing and win by default. Alternatively, the landlord might offer to settle or return your money in full at this point, in which case make sure they also agree to pay the court fee. Otherwise, your claim will be decided by a judge after a hearing. If you win, you're likely to recover the court fee and some very limited expenses from the landlord, as well as the disputed amount. If you found this video useful, you might also be interested in my video on dealing with demands for rent arrears. I'm Barrister Daniel Barnett. Here's another video you might like. Thank you so much for watching. Bye bye.